Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. I'd like to welcome you to this morning's webinar where we're going to discuss the right to know law for law enforcement. A couple preliminaries before we jump into the session. First, all the PowerPoints that we use with these sessions are on the OOR website under the Training tab. Go there, you'll see a sub-tab for the PowerPoints. You can scroll down, and this one is entitled, Right to Know Law for Law Enforcement. Feel free to download that at your convenience if you'd like it for future reference, or if you're conducting any sort of local training, go ahead and do that, as well as use any of the other PowerPoints that we might have. This session is being recorded, and occasionally folks will ask for a copy of those recordings. You can contact the office, and they'll do one of two things. One is it's possible that they could establish an internet link where you could go into a file sharing program and be able to access the recording. Otherwise, you may be asked to simply mail in a flash drive with a note and a self-addressed stamped return envelope. And they'll be happy to make a copy of the recording and mail that back to you. In those instances, turnaround's usually about a week, so it works out fairly well. Now, as you can guess, the way this session works is that we've got the PowerPoint with most of the information on it and me talking in the background. You're invited to submit your questions as we're going through the presentation. Just type them in the chat feature, and I'll do my best to answer them as we're going through. But I have, two conditions. First is that we are talking about the right to know law as it applies to the law enforcement community. So we would ask that you stay on topic. Second is that please keep your questions as brief as possible. It can be awkward for me to sit here and read through a couple paragraphs and then try to answer while everyone else is waiting patiently. If it does look like you've got something very specific or complex or unique to your situation, we'll do one of two things. First, we may wait until the end of the presentation, and I'll come back to you, and we'll talk about it for the benefit of everyone who's still logged on. Or we can take the conversation offline. I'll invite you to contact the office either through phone call or email with your questions, and they'll get you steered in the right direction. Pardon me. So all those preliminaries out of the way, let's just go ahead and jump right into the presentation now. Why is the right to know law important? And it really comes down to a couple of factors, access, transparency, and good government. And I like to begin all of these sessions with what I call a foundational statement. And in this instance, the purpose of Pennsylvania's right to know law is to give the public access to public records. Now, under people's First Amendment rights, they have a right to petition their government. And essentially, the right to know process is one form of being able to do that. But also understand the limits here, that the right to know law is to give the public access to public records, and that's it. There's a lot of misunderstanding about the right to know law, where folks believe that it's some form of Google for government and that they can submit any sort of questions and it's government's job to run around, find the answers, and respond. Maybe under certain circumstances that's accurate, but not through the right to know law. Okay, something's popped up here. I have CREA questions that may be complex. Okay, well, we'll be talking about CREA here, Mr. Pulaski, and feel free to submit them when the time comes up. Okay, may involve a conversation. Well, I'll give you information at the end of the session on how you can reach out to our office. Also, we'll include some CREA information with this presentation. Okay, then moving on here, there are some basic foundational aspects of the right to know law that you need to be aware of. Now, I should put this caveat in here. The whole purpose of this presentation is that we recognize the right to know law can be fairly complex. However, from a law enforcement perspective, you're not expected to be an expert on all facets of the law. So what we've done here is kind of condensed those facets that we think are important to members of the law enforcement community. So, we're gonna kind of touch on the highlights here, plus focus on those specific areas of the law that I think if you're working in the law enforcement world, you need to know about these tools that are out there. And notice I said tools because based on what I'm about to say here, a lot of people get concerned that, oh my gosh, everything in the office is going to end up on the front page of the paper, or somebody's Facebook page, or anything that's confidential in the office suddenly is going to have to be turned over because of no request. And that truly is not the case. And interestingly, Mr. Pulaski here has jumped right on it with mentioning CREA, which is another tool that can be used by the law enforcement community to prevent the release of otherwise confidential records. So let's talk about these basic fundamental precepts of the right to know law. First is your starting point. Every record of an agency is presumed to be public. Yeah, that's where you start. Okay, so everything we have, every piece of paper, every email, every database element, etc., is presumed to be public. But what if we have concerns about releasing this information through the right to know process? Well, there is a very good chance that there are tools that exist that would allow you to prevent releasing those records if you have a sound business case for doing so. It's just that, and this is the second very important point, agencies, meaning your police department, bear the burden of proving that a record is not public, and you have to make a legal and factual case for doing so. Okay, so starting point, every record is public. But if we have concerns and we feel the need to deny this right to know request to prove that it is not public, the agency bears the burden of meeting its legal case to prove that that is so, that the record is not a public record. Now, there are some things that every agency needs to do. First, probably most important, is that you need to appoint an agency open records officer. Now, depending on your municipality, you could have one agency open records officer, or also known as a right to know officer, that covers soup to nuts. They cover the administrative side of the municipality, like, pardon me, public works, it could be zoning, it could be code enforcement, as well as law enforcement. But then you could also have a municipality where they've got that person on the administrative side, but there's a second open records officer just for law enforcement. And there are some advantages to that, especially given what CREA says about limiting who can have access to certain records in the law enforcement community. There's nothing in the right to know law, and there's nothing in CREA that explicitly says law enforcement must have a dedicated right to know officer. But I'm simply putting that out there as food for thought, that maybe you want to consider that given some of the limitations that CREA places upon who can have access. Because if you have that one person functioning as an agency open records officer and they're not part of the law enforcement organization, it's possible, and if you could see me, I've got possible in quotes, that there could be a possible CREA violation. But again, nothing explicitly legal that says you should do that. Only I'm putting it out there as food for thought. Okay, so what must the agency do? Well, you have to post all the contact information for your agency open records officer. Look at this from the public's perspective. I'm not intimately familiar with the right to know process, but there's a record that I need to see, or there's a record I need to get a copy of. How do I do that? The easier you can make it for the public to work their way through this process with the minimal amount of surprises, the smoother it's going to be for you, and the easier your job is going to be. So the more information you can get out there about what the playing field looks like before the public ever enters the game is going to be better. Okay? Typical transparency sermon here that I'm putting out. So you need to post the contact information for the agency open records officer. How do I get a hold of them? What's their email? Is there a phone number that I need to know? You have to have a form available, because if I don't have a form, you should have one available for me. Sorry about that. I'm dealing with a little bit of allergies here in my old age. Then you need to tell folks about the appeal process. Now, there is something about law enforcement that is unique when it comes to the appeals process, and we're going to deal with that. There are actually two possible appeal avenues, and it all depends on what you use, what tools you may use to deny a request, and we'll talk about that. Then you need to instruct all staff that if they receive a right to know request, let's just say it's an officer on the street, or it's the staff at the counter when I enter your police department, if it's a right to know request, they need to get it to the arrow as soon as possible. Okay, because the possibility is there that if there is any sort of delay in getting the request to the arrow, you could possibly be abrogating your rights to deny the appeal, or I'm sorry, deny the request, or if ultimately an appeal is filed, because there are hard deadlines built into this law. Little, if any, wiggle room. I probably shouldn't even say little. No wiggle room. All right, so you want to make sure that the right to know requests get to the arrow as soon as possible. And then we ask finally that you notify us here at the Office of Open Records who your arrow is. On the website, there is a database statewide of all the arrows. We like to keep that as accurate as possible, and we realize, people move on, they get promoted, they retire, maybe one department to another, whatever. So it's important that this database be kept up to date for a number of reasons, one of which is that if we receive an appeal here at the Office of Open Records because you've denied a right to know request, we reach out to the arrow as the point of contact. And at that point, it's a very important thing that's going on. So if that information is not kept up to date, if it's not accurate, then we've got a problem. Okay, things you cannot do under the right to know law. And you cannot adopt a policy or a regulation which, number one, limits the number of records or requests that a person files in any specific time frame. You can't say, ma'am, I'm sorry, you've already filed 3 requests this week. That's all we allow. The law allows her to file a dozen requests this week if she wants to, or more. Let me go off script here a little bit. If you have what we would call a problem requester or a frequent flyer, there are things that you can do to make those people go away. I would suggest that you attempt to participate in the webinar that we do on the right to know law issues, because most people who are legitimate requesters are willing to pay a nominal. People who are filing right to know requests because they've weaponized the right to know law, or they are just being a pain in the neck, they're usually not willing to pay for records. So sit in on that webinar, and I think you'll get some good tips on how to deal with problem requesters. Okay, the other thing that you cannot do is compel a person to tell you why they are filing a right to know request. And, even in the case of problem requesters, they're filing requests just to see you work harder. Well, you cannot deny a request based on the reason or what you think the reason is. Remember when I said you bear the burden, You have to make a legal and factual case as to why you're denying the request. And simply saying that this person is a pain in the neck is not a valid legal reason for doing so. Okay, so you cannot force a person to tell you why they are filing a right to know request. Although, in most cases, it's self-evident. Okay, I like to portray the right to know process as an obstacle course. You've got the start, which involves receiving the request. And you've got some deadlines in this. If you've ever kind of followed like the Olympics, in order to even qualify for the Olympics, you have to meet a certain time standard. So you've got all the deadlines that are involved. Then on this obstacle course, you've got 2 hurdles that need to be jumped over. And in front of the second hurdle, you've got 3 hoops that you need to make it through. So as we proceed with the presentation here, this is kind of the outline that I'm going to follow. So let's take a look. First offhand, you receive a request. It comes into the arrow. You now have 5 business days in order to provide your initial response. Now, business day, typically it's Monday through Friday. Saturday and Sunday doesn't count. If your administrative offices are closed for a holiday, that's not a business day. If there's a weather emergency and your administrative offices are closed, that's not a business day. So you kind of look at the calendar, and let's say the request is received today. Well, then tomorrow is your first business day. And then you count out the 5 business days. Close of business on the last business day is when your initial response is due. Now, let's say for whatever reason, you cannot provide okay, periodically your sound gets very low or cuts out. Okay, let me get a little closer to the microphone here, and hopefully that won't be the issue. Okay, so let's say that for whatever reason, you're unable to provide a response within the initial 5 business days. The right to know law allows you to take a 30 calendar day extension. Notice the difference. Calendar day would include Saturday, Sunday. It would include a holiday. It would include closure for a weather emergency. 30 calendar days. Okay, but in order for the extension to be valid, there are some conditions that need to be met. First is that you need to invoke the extension within the 5 calendar day window. You can't wait until what would be the 6th day, suddenly realize, oh gosh, I forgot about this right to know request. Well, we'll just take the extension. Unfortunately, because of these hard deadlines, you've denied the request by default. It's what's legally called a deemed denial. So you get it in within the 5 business day window. It has to be in writing. And, if they submitted the right to know request by email, you can respond back by email that, hey, we're taking this extension. You have to provide a reason. And if you go to Section 902 of the law, it maps out 6 reasons as to why you can take an extension. It could be that we keep these records off-site, and it's going to take us longer than 5 days to review them to see what we have. Or it could be we want our solicitor to review the records to make sure we're not giving out anything we're not supposed to. And then the other deadline you need to be concerned about is that if you deny the request, the requester then has 15 business days to file an appeal through either of the 2 avenues that we'll outline here coming up. Let me get a sip of coffee here real quick. Okay, so we're on the obstacle course and we're coming up on the first hurdle. We have to answer a question. Are they asking for records? Okay, now that seems rather obvious, but if you look at the right to know law, you go to the definition section, there's actually a definition for what a record is. And this is important because, like I said, this is the first hurdle. A record is any information, regardless of its physical form or character, that documents a transaction or activity of an agency and is, et cetera, et cetera. Okay, what does that highlighted phrase mean? Documents a transaction or activity of an agency. Well, it needs to be about the department. Now, let me give you a quick example. Well, a couple examples here. Let's say that I send an email to one of my coworkers and it says, "Hey, I hear a new restaurant's opened up downtown. You want to meet for lunch tomorrow?" Or something like, "What do you think of the trade so far with the Eagles and how do you think it's going to affect their season this fall?" Or I'm picking up a gallon of milk on the way home. Okay, all fairly common communications, but none of them document a transaction or activity of an agency. Therefore, they don't rise to the definition of a record, and they would be denied under the right to know law because they don't make it over this first hurdle. They're off the obstacle course, out of the game. Okay. Now, let me put out another example because there's an important point here that I want to make. Let's say I'm sitting at home. I'm in my family room. I'm on my home computer. I'm on my personal Gmail account. And I send a message to one of the officers on my force that can you send me the case files on this particular investigation? Okay, now whether or not those case files rise to the level of a public record at this point are not important. Rather, the point I want to make is that just because it's my personal computer and just because it's my personal Gmail account doesn't matter. Okay. And it could be my smartphone. It could be, Yahoo, Google, whatever. All right. You cannot use personal devices and personal accounts to hide the public's business. Now, let me clarify that. You can use them to conduct business. Okay. And in this particular instance, I am conducting business. I'm asking for copies of case files. All right. Which is perfectly acceptable. There's nothing illegal, nothing unethical about doing that. But the point that I want to make is that they are still potentially considered public records, regardless of the fact that I'm using a personal device and a personal account. Okay, so I guess what I'm saying is there's nothing illegal about doing that, but just be forewarned that it doesn't give you any protection from the right to know law just because you're using a personal device or a personal account. It doesn't matter how the record is created or where it's stored. It's the content of the record that matters. And what we're looking for at this point is it documenting a transaction or activity of the agency, of the department? If it is, then it's considered a record and we move on the obstacle course. If not, it's off the course and you can deny the request because the person isn't seeking a record as defined by the right to know law. And that happens periodically. People will submit a right to know request. I want to see all of Officer Smith's emails. Well, if Mr. Smith is sending ones like going to the restaurant or picking up a gallon of milk, those are not considered records. They're not discoverable under the right to know law because they are not documenting a transaction or activity of an agency. And just as an aside here, whenever you're trying to figure out what a law says and how it works, never skip the definition section because that really is where the meat is and how you apply the subsequent language that you'll find in the law itself. Okay, and this is a fine example where we're looking at the definition of a record and how it immediately takes all these communications off the table. You don't have to worry about casual emails being released, or any sort of casual message released through the right to know law, because in this instance, it wouldn't meet the definition of a record. So like I said, it's off the table. Okay, so what are records? The other part of this definition is any information regardless of its physical form. Well, yeah, paper, it could be letters, it could be memos, any other sort of document. The right to know law addresses electronic records. So yeah, emails, Word documents, Excel spreadsheets, various database applications, um, phone records, text messages. Let me talk a little bit about deletions. Okay. Mostly under the right to know law, you're only required to provide records that you have in your possession. Well, what if I've deleted my emails, okay, or my phone records? With emails, there's a case out there. It's called Early versus the Pennsylvania Department of Labor and Industry. And what it comes down to is that, if a message has been deleted, you've got to take a look at just how far it truly has been deleted. Like if I delete a message off my laptop, if I delete a message, or I'm sorry, an email, it's not really gone. It's in my deleted items folder. Okay, so I wipe out my deleted items folder. It's then in my recycle bin. Okay, so it's still accessible. It's still there. But then I take out the trash. And so it's no longer on my laptop, but we have an email server. And that controls all the emails for the office. And that is accessible by internal information technology staff. So the message is still there. It's on our email server. So we still have possession of it. Now, periodically, the IT staff will come in and clear out messages from the server because, we need the space. Once it's off the server, the IT staff can't recover it. At that point, it's truly deleted. And that's pretty much what this case says, that if you can no longer access the message or the record using internal resources and internal staff, then at that point, the record is no longer accessible and you no longer have it in your possession. Okay, so that's how that works. Now, phone records are a little different. Let's say you're using your smartphone and someone submits a right to know request. You have an obligation to conduct what's called a good faith search for those phone records. If you've deleted them off of your smartphone, usually all you need to do is contact the phone provider. Now, the records are out there. There's a federal law that says they have to maintain these records for a certain finite period of time. But typically, the phone provider will require that you submit a warrant to obtain those records. Under the right to know law, you do not have to obtain records using a warrant. Okay, so at that point, because the phone carrier is basically denying you access to the records that you no longer have in your possession, you can say, those records are no longer in our possession, and we're denying the request based on non-possession. Okay, so that's how it works with phone records and text messages. Audio recordings, security camera footage. Let me talk about security camera footage here real quick, because this is an interesting one. Again, based on case law. Let's say that you are in a building combined with your administrative staff for the municipality, and there is a camera out front that covers the front entrance and the the parking lot, front street, whatever. If that camera is controlled by the police department and the recording equipment, monitoring equipment is monitored by the police department, The right to know law does not apply. Rather, it's another law called Act 22, which I'll cover here in a moment. If, however, the recording equipment and monitoring is done by the administrative side of the municipality, then the right to know law applies. Okay, so understand that distinction. Law enforcement, Act 22. Non-law enforcement, right to know law. And then finally, social media. This would be, your websites, Facebook pages, Twitter accounts, et cetera, et cetera. Anything you use to get the message out to the community about what your department is doing. Absolutely nothing wrong. And I think it's, probably a good thing. Very helpful to use social media. It's the way, the public expects us to do business these days. Just be forewarned that if you're using social media, there's a very good chance you are creating public records when doing so. Fortunately, because those records are already out there in the public domain, when you receive a right to know request for, let's say, comments on the Facebook page, you can simply tell those requesters that that's on our Facebook page. Here's the link to it. And you've satisfied, your requirements under the law. It's considered a valid response under the right to know law because you are providing the requester access to the records that they're asking for. But just keep that in the back of your head that if you are using social media, chances are you are creating public records. Okay, Act 22, what I was talking about. This was passed back in 2017, and its intent was to take video footage collected from dash and body cams out from under the right to know law and create this new law called Act 22. But interestingly, it also includes footage or also includes language that includes security camera footage. But that footage or that, like I said, it must be under the control of law enforcement. Now, under Act 22, a law enforcement agency is any entity that employs a law enforcement officer. That, we found, can be a school district, it can be a private charter school, it can be Amtrak, it can be any other organization that employs a law enforcement agency. Okay, so file that away. The definition of a law enforcement agency under Act 22 is very broad. Now, the points that I want to make here, in addition to that, is that number one, this footage, dash cam, body cam, security camera footage in the possession of a law enforcement agency is not covered by the right to know law. And the Office of Open Records has nothing to do with these records and how you access them. Rather, the individual files a separate request, and there's no form for this, even though we put a form on our website, and just because no one else seemed to be taking the lead at the time. But they have to submit a request to the law enforcement agency within 60 days of when the footage would have been generated. And there's quite a few other requirements that they need to provide with their request, like, who's on the footage, et cetera, et cetera. Now, the police department has 30 days to provide a response back to the requester, which, that's significantly different than the right to know law. And the police department can charge any reasonable fee. For instance, under the right to know law, you can't charge for labor. Under Act 22, you can. So as long as the fee is reasonable, you can submit an invoice to the individual prior to ever releasing any sort of footage. And then if there is a dispute, let's say you deny the request, the appeal that the requester would file goes directly to the Court of Common Pleas, or in the case of state police, the Pennsylvania Commonwealth Court. Okay, and when they do that, they have to file, or they have to pay the filing fees, et cetera, et cetera. So it's much more difficult to get this footage under Act 22 than it used to be under the Right to Know law. But that's what Act 22 is all about. These days, if you have questions about it, I would suggest reaching out to the Pennsylvania State Police, because I think of all law enforcement agencies, they probably see the most activity, and they can probably provide your department with the best advice on how to proceed if you do receive an Act 22, pardon me, if you do receive an Act 22 request. All right, so that's what that's all about. Now, we're coming up on the second hurdle. So there are some additional questions that we need to answer. And if we go to Section 708B of the Right to Know law, there are these things called exemptions, and there are 30 of them. An exemption is a definition of a type of record that can be withheld if the department feels the records fall within those the definition of the record. Hey, questions popped up here. Do you know what unit or division in PSP we would contact? You know, I would use as a starting point, I would reach out to the Right to Know officer, and they can probably get you steered in the right direction. They have kind of a sub page on requesting records, and I think that kind of branches off depending on the type of record that you're looking for. And I do know that they have a page dedicated to Act 22, but I'm not sure they have any specific contact information for that. So I would start with their Right to Know officer, because this is an interesting point. I'm glad you bring this up. Act 22 requests go to the Right to Know officer of the department. Okay, that is the only connection between the Right to Know law and Act 22, is that you're required to have a Right to Know officer, so give your Act 22 request to them, and that's your starting point. Okay, thanks for bringing that up. Okay, so we're answering the question, do any of these exemptions apply? And like I said, there's 30 exemptions in the law, but there are only 3 in most instances that law enforcement needs to be familiar with. And that's the next slide, I think, that we're going to cover. Okay, so do any of the exemptions apply? And if so, are we going to invoke them? Because these exemptions are not mandatory. Rather, they're invoked at the discretion of the department, which means even though the records requested by an individual might clearly fall within the definition of one of these exemptions, you have the discretion to still release the records if you want to. And then the next question we have to answer, this is the second hoop in front of the second hurdle. Are there any federal or state statutes or a judge's order that make these records non-public? And this is language taken from 306 of the law. Now, Mr. Pulaski, this is where CREA comes into play, because CREA is a state statute, the Criminal History Records Information Act, that identifies a broad spectrum of records that can only be shared within the law enforcement community. Okay, and it's broader than the Right to Know law. And the important point to make here is that CREA removes the discretion that you would otherwise have under the Right to Know law to release records, because CREA says you cannot release these records outside the law enforcement community, whereas the Right to Know law says you may withhold these records. Okay, and going to Section 306, any law that says a record is confidential trumps the Right to Know law. And you can use the provisions of that law to deny your request and meet your legal burden, as I said at the beginning, where you need to meet your legal burden in order to deny a request. So for law enforcement, you've got this very important and powerful tool, CREA, that allows you to withhold records if you deem it inappropriate for doing so. And I'll just give you a quick example. Police intelligence information. Let's say your department keeps files on suspected gang activity in the municipality. If you look at the right to know law, there is no language that covers police intelligence information. You go to CREA, and there's a whole section there on intelligence information that can only be shared with other law enforcement agencies. So you can see how CREA covers a broader spectrum of records, and CREA doesn't give you a choice. You must withhold these. And I'll say also that CREA has its own definition of what a law enforcement agency is, and that is much narrower than Act 22. Okay, so under Act 22, you could have a school district being identified as a law enforcement agency. Under CREA, no way. All right, it has to be, a certified law enforcement agency. Okay, questions popped up. Are exemptions invoked on a case-by-case basis, or once you release a type of record in one case, you have to release all? No. Good question. You are not establishing a precedent in any way by choosing to release a record, even though it may clearly fall within the definition of an exemption. It is a case-by-case basis. And I'll put in a caveat there and say usually, typically, okay? There's always an exception, and I don't want to mislead you, but you look at it on a case-by-case basis. Good question. Okay, so if there is any other law that says a record is confidential, that law trumps the right to know law, and when you deny the request, you can use the provisions of that law as your legal argument for why you are denying the request. Then we come up to the third hoop before the second hurdle, and this is the record protected by privilege? And in this case, it's typically attorney-client privilege with your solicitor. Any communication considered sensitive between an attorney and their client is protected by attorney-client privilege. And that's governed by statute, and it's also referred to in Section 305 of the Right to Know Law. And it can be, that is confidential. So you would use that as the basis for denying your request. Another question's popped up here. I want to release a record, but CREA prevents me from doing so under the definition of investigative information. Okay. All right. A couple things. I would, first offhand, there's a very good resource for CREA on the Attorney General's website, General Pennsylvania. So I would suggest downloading that guide and reading through that to see what, if any, guidance that would provide. If you still don't feel comfortable, then I would reach out to the Attorney General's office. They are pretty much the, because they are the chief law enforcement agency for Pennsylvania, they're the point of contact for any CREA questions. So I'd take a look there. Okay, sorry I'm cutting out on you. Go to the Attorney General's website and look at their CREA handbook. If that doesn't answer your questions, call the Attorney General's office, and they can steer you in the right direction as far as CREA. Hopefully that came through. Okay, moving on. The exemptions in the right to know law that we need to talk about. There are three. The big one is 708B16, criminal investigatory records. Now, this would be any record critical to a criminal investigation that, could jeopardize the investigation, or it could be a cold case. The right to know law makes no distinction. It could be, 20 years old, conviction, jail time, whatever. You can withhold those records under 708B16. Now, it does not include blotter information or an incident log. Okay, those are specifically mentioned in the Right to Know law as not falling under B16. So that information you would have to give out. You know, Officer so-and-so was dispatched at 3:13 a.m. To investigate a noise complaint. You know, that is public information. But any investigatory narrative that might be included would or potentially could be withheld by invoking the B16 exemption. Now, this is an important point here, and it's again brought up through case law. There is a decision with the Pennsylvania Commonwealth Court that goes back quite a few years where a police incident report is considered inherently investigatory, and therefore the B16 exemption applies, and police incident reports are not considered public records. Okay, I'll repeat that. Police incident reports are not considered investigatory records. Citation for the case is, I think it's either 2010 or 2012, that it's Pennsylvania State Police versus the Office of Open Records. And I do not have the citation in front of me, but I think you can do a little bit of research on that. Justice McCulloch wrote the decision. But yeah, Pennsylvania State Police versus the OOR, I think it's 2010. Okay, and so that comes down to, well, we get all these requests for incident reports, and some of them, they're from the media for news stories. Well, some departments actually have two versions of incident reports, and they have software that takes care of this, where they will release, all of the basic data for an incident, but it won't include the investigatory information. That gets scrubbed or, blacked out in some way, deleted. So, then they have their own internal investigatory or incident report that does include investigatory information. All right, then we come up on the next exemption, and this is 708B17, non-criminal investigatory records. And, this varies from department to department. Let's say email you the citation. I'll do what I can. I'll have to take a look at what I currently have. Okay, so B17, non-criminal investigatory records. Some departments, the small municipality, they have a police department, but let's say they don't have codes enforcement. So they receive a complaint about some neighbor where their yard is a mess. They haven't mowed the grass in 6 months. Guess who gets sent out to check it out? Well, it's basically a codes violation, not a criminal investigation of any sort. But there needs to be some sort of paperwork. Well, let's say that the person who owns the property wants to know who filed the complaint. Well, using B17, you can deny access to those records because it's a non-criminal investigation. Or another one, let's say the department, an officer gets sent out to investigate an apparent suicide. Based on initial investigation at the scene, it's obvious there's no criminal activity. The person sadly took their own life. They left a note, no evidence of a break-in or any sort of altercation. They took their own life. Okay, non-criminal in nature. B17 could apply to any sensitive records related to that non-criminal information. Very useful tool. And then finally, we come up on 708B18, emergency dispatch. These are the 911 recordings, usually kept by your county 911 center. Just for the good of the order, this applies to phone calls and radio recordings. And basically what it says is that these records can be withheld using 708B18. Very tightly written exemption. It's really hard to get these recordings under the Right to Know law. It's impossible, actually. But you say, well, wait a minute. I've heard 911 recordings on the radio or on TV. Well, that's because of that discretionary clause in the right to know law, where the county EMA or maybe the chief of the department made the decision that it's in the public interest to release these recordings. Okay, they can do that. But if you don't want to release the recordings, 708B18 allows the county pretty tight tools for doing so. Okay, appeals. Let's say that the person has not made it through the obstacle course and you've denied their right to know request. The appeal, and this is an important distinction for law enforcement, if you have used 708B16, meaning that the records requested were critical to a criminal investigation, so you've invoked B16 as the reason for denying the request, the appeal goes to your county district attorney. And it needs to be, they have 15 days to file their appeal. The DA will usually have like a deputy or an assistant DA assigned as the appeals officer who will review the case to determine whether or not they feel the department made the right decision. These decisions, the answers to the appeals, are actually filed on the Office of Open Records website, and you can go there to a specific tab, read through, like maybe how your county has ruled on B16 appeals, just to get an idea on how they are treating specific issues. Any other denial that does not involve B16 gets treated like most appeals that come directly to the Office of Open Records, okay? If it involves B16, goes to the county. So you would want to advise the requester when you're telling them their appeal rights that they have 15 business days to file their appeal with the county district attorney. Here's their contact information. If it doesn't involve B16, then you have 15 business days to file your appeal with the Office of Open Records. Here's their website address. And I say website address because our website has the functionality to file an appeal online. As a matter of fact, that's how we prefer it because then it goes directly into the docketing system. Okay, but that's the distinction. B16 cases go to the county. Other cases, including CREA cases, come to the Office of Open Records. Okay, costs, real quick here. You can charge for right to know responses. And it comes down to, if it's hard copy, it's up to 25 cents a page for typically 8.5 by 11, 8.5 by 14, single-sided black and white copies. You cannot charge for electronic records. So if someone is requesting emails, you provide the emails with no redactions. If that's the case, there's no charge for electronic records. Everything else, you can charge actual costs or postage. You cannot charge for labor. Okay, does a CREA-based denial get appealed to the district attorney? No, like I said, if you're not using B16, it comes to the Office of Open Records. Okay, now this is presuming someone has filed a right to know request and you are using CREA as the legal basis for denying the right. If they're filing it under the provisions of CREA and you're still denying it, I don't know what, if any, appeal mechanism there is. But hopefully that answers your question. Okay, now, any other legislated charges? Okay, all right, I'll say this again. If you're denying the case, if the person has filed a right to know request and you are denying the right to know request by using CREA, it comes to the Office of Open Records. If you are denying the right to know request using B16, it goes to the district attorney. Hopefully you heard that. Now, back to the presentation here. Any other legislated costs take precedent over the right to know law and the fee schedule with that. This is important because of accident reports. Accident reports and access to them is not covered specifically under the right to know law, but rather it's covered under the Pennsylvania Motor Vehicle Code, which says you can charge $15 for an accident report. Okay, $15 clearly exceeds the right to know law fee schedule. Thus, you charge the $15, not the 25 cents a page under the right to know law. And if you have any other laws that define how you access records and what the costs for that access may be, that takes precedent. That trumps the right to know law. Okay, so we are at the end of the presentation. If you have questions, now's the time to get them in. However, I also want to suggest that you take a look at the Office of Open Records website. There are a wealth of resources there, including a law enforcement guide that covers a lot of what we've talked about here today. Okay, questions popped up. If your agency holds a document from an outside entity or agency as part of a criminal or non-criminal report, does that outside agency have ultimate say on whether their document gets released? Do you refer the requester to that other entity or agency for that particular document? Actually, if you have it in your possession, then the right to know law applies to you if you've received a right to know request. And the other agency is kind of out of luck. Okay, so the other standards apply to you. If you are, let's say you're not a law enforcement agency, but you have a record. Okay, first offhand, you cannot invoke B16 because you're not a law enforcement agency. You can invoke B17 and claim that it's a non-criminal record. However, this is an important point. You must have statutory authority to conduct the non-criminal investigation. Okay, that's an important distinction. For instance, we've had school districts deny access to records based on it being a non-criminal investigation, but they did not have statutory authority to conduct the sort of investigation they were claiming the record was part of. So we ruled that they had to release the records because really, like I said, they had no statutory authority to claim they could conduct such non-criminal investigation. Something else that came up a couple years ago, this is kind of, well, it's kind of funny from our perspective. We had a township claim that a right to know request and responding to it was a non-criminal investigation. No, it was a novel approach, but a right to know request is not a complaint of any sort that would be considered part of an investigation. So we ordered they had to release those records. Okay, so it depends. If you're a law enforcement agency, you have statutory authority usually to conduct any sort of criminal or non-criminal investigation. If you are not a law enforcement agency, we would take a look at, okay, what sort of statutory authority do you have? And if you're claiming non-criminal investigation, you should be able to circle back to say you have statutory authority to conduct said investigation. And an example would be, like a codes violation. It could be a person not cutting their grass, or maybe a building code violation of some sort, like that. Hopefully that addresses what you're seeking with your question. Okay, but back to the website, wealth of resources there. And if you have further questions, take a look at the website and you're going to find, the phone numbers and email accounts that you can submit questions to the Office of Open Records. And they have staff dedicated to responding to your questions. And the turnaround time is fairly quick. Okay, so feel free to do that. But I want to thank you for your participation today. In 2 weeks, I think we're back to basics of the right to know law. It'll be Wednesday, 10 o'clock, and same procedures as we went through today. And look forward to hearing from you if you're interested in attending that. But some really good questions today. You're what we call a hot bench, where it shows you were paying attention and that you're on top of your game with what we're covering here. So again, feel free to reach out to the office, but thanks for your participation and have a great day, folks. We're going to log off now.